What are you going to be for Halloween?
Oh, well, I'll tell you, I have to start thinking about it, don't I? Tomorrow is Halloween.
Yeah, it's tomorrow. What about Charlotte and Aiden? Do they know?
Yeah, I think I will maybe come as the president.
I think that's a great idea.
Center for Law and Justice, and of course, one of the president's counsels, Jay Sekulow, and Fox News legal analyst Greg Jarrett. I got so much for both of you. You, Jay, need to first take a victory lap because the ACLJ, your group where you're the chief counsel, you led this case in the IRS. They did weaponize the IRS. They did turn them against anybody that was conservative, Tea Party oriented. A big win, but Obama kind of also got what he wanted.
Yeah, well, I mean, look, it took 3.5 years of litigation to get there. Our team did a fantastic job of litigating this, and the end result is not only an acknowledgement of the wrongdoing, but also a complete change of policies. There will be an order signed by the court in the next week or 10 days. That's going to include declaratory relief, meaning that the policies will go forward and they will not be able to do what they did, which is violate the First Amendment. And, you know, whether you're right, left, or center, the idea that the government would target somebody because of the name of the organization or the political position they were espousing violates the fundamental aspects of freedom of speech, freedom of association, and we've now got an agreement with that. So it's a very good day for our clients. But, Sean, it was 3.5 years. A lot of those groups, as you know, were not able to continue to activate. And by the way, it wasn't just Tea Party groups. There were groups in that were just because of the name that they had in their organization, they were targeted for this. And it really beyond the pale, but the end result was a good settlement.
I remember in April of 2010, I was in Atlanta. It was like 25,000 people there, people all over the country, massive crowds that were energized. These groups formed. They wanted to oppose Obama's policies, and they got stopped in their tracks. So this did have a big impact.
We got a result, but, you know, the harm was done. There's no question about it. I'm glad the case is over, glad it's resolved, glad the government took the liability and the responsibility that they did for wrongdoing, but it took 3.5 years of litigation to get there. Glad we won, glad it got resolved, glad General Sessions, Attorney General Sessions signed it moved this forward. He issued a statement today. But at the end of the day, 3.5 years of litigation to do what? Defend a fundamental right under the First Amendment. Should have never happened in the first place.
All right, Greg, let's start with the laws. By the way, you're an amazing. I love the fact that you're so organized as a lawyer. Sean, here are all the laws in this case. Sean, here, you're a great partner to have on the show. We appreciate it. Laws potentially broken in the Uranium One deal. Let's put them up on the screen so our audience can understand it. Explain. Let's start there because this.
Right.
We sold out national security.
This is huge. The first 6 statutes on the screen are the anti-corruption pay-to-play statutes. You cannot use your public office, Secretary of State, to confer a benefit to a foreign government in exchange for money. The evidence appears to be there. And because she used her charity, allegedly, that would be racketeering, which, you know, the government goes after organized crime and the mafia for that.
Okay, now, so all of these statutes, these are real crimes. I keep saying we can't have a two-tier justice system. We can't have one justice system for the Clintons that mishandled, destroyed, classified, top secret, special access program information, all of these issues involving the kickbacks, the paybacks, the pay-to-play. So the question is, how did they get away with it, and do you think they slide this time?
The Clintons are escape artists that would make Houdini proud. Whenever they are caught dangling their feet over the edge of illegality, they usually dummy up. Hillary Clinton, I'll give you an example, interviewed by the FBI, said 39 times, "I cannot recall." It was so short because she could only recall her name and date of birth. You know, she pretends like she's dumber than a bucket of hair when it serves her purpose and the brightest person in the room when it helps her.
Let's go to the dossier crimes and the scandal according to them. We'll put them up on the screen here. This dossier is getting to be a bigger, because they paid $9 million.
Right. You can't pay millions of dollars to foreign nationals because that's against the federal election laws you can see there. And you can't hide it by filing false or misleading reports. Now, I've been hearing Democrats say, oh, those are just civil penalties. They are not. The government produces a book. It's 319 pages outlining the federal election laws and all those who have been criminally prosecuted and ended up in prison.
And quickly, the laws potentially broken in the email scandal, which now, thankfully, is finally this week they're back to this.
The Espionage Act, 2 counts which were tortured and twisted by James Comey. And then the other 2 is removing classified materials from a government building. The final one there, destroying 33,000 documents.
That's called obstruction.
Yeah.
Yeah, they were subpoenaed documents.
Right.
Yeah.
By Congress.
All right, Jay, let me go back to you.
Yep.
When you look at Uranium One, you look at the Russian dossier, here's my question and where my mind goes on this. So the dossier, they have the former MI6 guy. He's
right.
Fusion GPS. He's paying Russians for phony information. And then I've got to wonder, was that the information? Because Sarah Carter and John Solomon reported that there were FISA warrants, another warrant. I'm wondering, wow, could they have used phony Russia propaganda to get... Yeah, go ahead.
Yeah, well, let me tell you something. If in fact the dossier was the basis upon which a FISA warrant was issued, you're talking about a whole host of legal issues that Greg will have to do another chart, because you're talking about going to a court, which is a FISA court is a court, and getting a warrant to basically eavesdrop, tap, listen in on conversations based on a document that was not only unverified, as James Comey said, by the way, and salacious and unverified, his own words, but ask this question. Why was the FBI considering paying for it at some point in this process? So that question has to be asked. And I go back to this whole concept, which is something we've been talking about for a long time, and that is, if this dossier was a political creature, which we now know it is, no question about it, it was they call it opposition research. But if Christopher Steele was utilizing Russian assets to get this information, and then, of course, it's been, as James Comey said, unverified, and they went to court to get FISA warrants, you're raising a whole host of civil liberty issues, and who knows what they did and what they said to that court.
Inadmissible in a court of law.
Well, I'd file motions to suppress the subpoenas that have been issued and the documents that were resulted as that. I would file those motions.
I can name names tonight of people that are happy. Real quick.
The FBI has become this all-powerful, renegade, deep state agency. They covered up the dossier information. They covered up the Uranium One information. Now
that includes Mueller? And that includes Rosenstein?
Yeah.
And that includes Comey?
Right. And Andrew Weissman. All 4 are on this Trump-Russia investigation, and they are so compromised here that they need to start answering questions before Congress.
We thank you both. We're only getting started. So much more coming up. Stay with us. We've been calling for special counsel to investigate Hillary Clinton and numerous scandals. And now the Washington Times is reporting, quote, Clinton email case far from closure as the FBI hands over more classified documents to state. And tonight, the American Center for Law and Justice is reporting that the FBI is reopening its FOIA request into the Clinton Lynch tarmac meeting and much more. Here with reaction. One of the president's attorneys, chief counsel, American Center for Law and Justice, Jay Sekulow, Fox News, anchor attorney Greg Jarrett. You broke this with, you were lied to by the FBI originally on your FOIA request. They said no such documents exist. There, in fact, was a back and forth between the FBI and the Justice Department, some, 481 pages. They actually put talking points together, and they're not supposed to be political. And they never sent you the talking points. They just put a black page up. Where are we now?
Yeah, well, let me tell you what's happened. So, we put in the request about and it says on the letter, the meeting between Attorney General Loretta Lynch and former President Bill Clinton. And the FBI came back with an initial letter saying there are no documents that we have pursuant to your request. Those documents don't exist. We then did the same request to the Department of Justice. They didn't respond at all, so we went to federal court, got a court order demanding a release of the documents, and lo and behold, when we get those documents 2 weeks ago, in it are documents between the FBI and the Department of Justice and vice versa. And, of course, the FBI was saying we had no such documents. So we obviously we raised it right here on your broadcast. We raised it with the lawyers at the various departments, including the Department of Justice, and a really unprecedented move. And, by the way, in those email exchanges, one of the email exchanges actually involved not just somebody in the FBI, but the chief of staff to James Comey receiving, quote, information on talking points on how to handle the Clinton Lynch meeting that took place in Arizona. But, Sean, we put a lot of pressure on the FBI to do what's right here since we got the documentation.
But you were lied to, and you don't
to...
have the talking points, so the DOJ and FBI should never...
Yeah.
What are you holding up? I can't see it.
Well, I'm holding in here a letter from the United States Federal Bureau of Investigation that says they've reopened the FOIA request and are now going through the documents to give us the documents that are relevant to our inquiry. And as it relates to the so-called talking points, this was in crisis management mode for the Department of Justice with Loretta Lynch the entire time. And by the way, James Comey made a big deal about that when he came out about Hillary Clinton in July of last year, saying, and when he testified earlier this year, he said, oh, it was that interchange at the tarmac that got me so concerned. Well, his chief of staff knew about it within hours after it happened. So that's number one. He didn't bother, by the way, to go back over to the Department of Justice and say, hey, this may be a violation of existing law or statutes. He didn't bother to do that. So
right.
I just want to be on the record on that. But number two, and this is important, Sean, the FBI has now reopened it, but you're right. They redacted not one-page email, a three-page email with the talking points.
Well, and the redaction, by the way, they claimed a particular privilege. I looked it up, the deliberations privilege. It doesn't apply to this case. No. Talking points don't constitute a deliberative movement. And so the privilege that they're citing on the redaction is absurd. It's also absurd that there were never, as James Comey said, any documents. He signed a letter saying, under penalty of perjury, there are no documents relating to the tarmac meeting. Now we know there are hundreds of them. So there are three possibilities here. Either Comey lied, or he didn't understand the request.
His general counsel and chief of staff got the request. So it's kind of hard for me to believe he didn't know.
Either they lost the documents and they've suddenly been found, or they lied when they said there were no documents, or they didn't understand the request. But the request, by the way, is standard boilerplate that every lawyer is familiar with. Hand over all documents pertaining to the tarmac meeting. That's everything.
But there's something else. There's something else here, Sean, really quick, and that is the letter from the FBI denying that there was any information relevant to us was signed by the same section chief for the Record Information Dissemination Unit, who's the same one that signed it a year later. It was almost a year ago, exactly, when they said there was nothing, signed by the same guy who came back and now has said, whoops, we're going to go back and check because obviously they know we got those documents.
On a scale of 1 to 10, how big is this, Jay?
I think this is very significant. So I give it a 10, and I'll tell you why. There is something. Just think about what took place on that tarmac. That is not the way equal justice under. That's been the theme of this. That is not the way equal justice under the law is supposed to work.
That's been my point for forever, and I agree with you. Guys, good to see you both. We'll stay on all these issues. A lot of news every night when we come back.
This new information was actually discovered through the American Center for Law and Justice's request for freedom of information from the Justice Department, looking into that tarmac meeting between Lynch and former President Bill Clinton. The DOJ eventually releasing more than 400 emails related to that meeting. Joining me now, Jay Sekulow, Chief Counsel with the American Center for Law and Justice. And Jay, if I remember correctly, the first time you put in that request months ago, you were told there were no documents responsive to that request.
Correct. So the first thing we did, we sent simultaneous document requests, one to the FBI, one to the Department of Justice. The FBI document request response was there are no documents responsive to your request. So they just said there were no documents. The Department of Justice didn't even respond back last year when we did this in the summer. And we ended up filing a federal lawsuit in October. Well, we got the court ordered the production of documents, and here they are. It's about 420 pages. We're still, by the way, doing a full analysis of this. But what's fascinating is three things right off the top. Number one, despite the FBI's protests to the contrary, there's actually email exchanges between the FBI and the Department of Justice. So when the FBI said there were no documents, well, that wasn't correct. Number two, that the FBI's senior counsel and chief of staff to James Comey was in the loop on this whole discussion of how they were going to handle this unusual event of the former president of the United States meeting with the then current Attorney General Loretta Lynch, while his wife, the former Secretary of State, who was also the Democratic nominee for president, was about to be questioned that very weekend by the FBI in relation to the email scandal. So all of this information comes in, and besides learning that the Attorney General had an alias, we do know that this reached the FBI, the Department of Justice. At the Department of Justice went as high as the Attorney General. At the FBI, at least to the Chief of Staff. to James Comey, and we now have an email that goes from the Department of Justice to the White House, to the press secretary there. And by the way, then the press secretary, basically throws the whole thing back to the Department of Justice, say they're not aware of anything. Well, they were given the talking points to give a comment on. Now, the talking points have been redacted, so we're going to go back to court for those, Shannon. But we've showed, this is just, by the way, phase one of what we're going to get. And also, it just tells you the initial interactions here. We've also learned, and again, we're analyzing a lot of information here, trying to check out who the people are on these emails. One of the individuals on the emails, Shannon, it was a senior counselor to Attorney General Lynch. Her last name is Herwig. She was the senior counsel to Loretta Lynch. She also previously served in the White House counsel's office, but interestingly, she now is the deputy counsel to Senator Dianne Feinstein, and of course, it's Senator Feinstein's committee, along with Senator Grassley's Judiciary Committee, that are investigating the whole Loretta Lynch investigation of Hillary Clinton and this whole situation that took place on the tarmac. So her former lawyer is now the lawyer for the ranking member of that committee. So there you have it.
I know you've uncovered a lot of interesting links and things we didn't know that you wouldn't have known potentially if these documents weren't turned over, as you first were told. There were no documents. You talked about fighting those redactions. Do you think you'll have success on that point so that all the blacked out material, you'll actually have some clarity on that?
Yeah, I really do, because I could show you what it looks like. Here's the black. This is the talking points. So we know who sent them, but what we don't know is what's in them. Now, she made statements. Loretta Lynch made statements after the fact. So what we're going to do is really simple, and that is we've gone back in and we're sending a request to the court for those redacted statements. I think we'll get them because there's no basis upon which they should have withheld them in the first place. So I suspect we're going to get them. Then we're going to take all of this information and hand it over in a chronology over to the Senate Judiciary Committee, who's conducting the investigation.
Well, they are a busy committee these days. So, Jay, we'll keep up on what you find and let us know when you get that next shipment or drop of these documents. Thanks, Jay.
Thanks, Hasham.